What's this now?
Good morning, Council.
Good morning, my lord.
Yes, the court is ready. We are starting the sitting now. The registrar called case number 1. The registrar called case number 1.
Thank you, my lord. Yes, my lord. Resume today, 3rd June 2021, virtually before His Lordship, Honorable Justice Sanusi Kado presiding. Suit number NICN CA 11-2020 between the Right Honorable Larry Okori Ode and 1, the Governor of Cross River State. 2, Government of Cross River State. 3, Attorney General and Commissioner for Justice, Cross River State. 4, Accountant General of Cross River State. My lord, the parties are absent.
Any appearance? Any appearance? Any appearance?
U.O. Igweni, my lord.
U.O. Igweni.
Igweni is, yes, Igweni is IGWENYI.
Yes.
Claimant, my lord.
For the claimant.
Yes, my lord.
Any appearance for the defense? Any appearance for the defendant? It appears there is no appearance for the defendant.
My lord, the defendant is online. I don't know if she's on mute. She's online. She's the one using Nokia 2.3. She's online. The lady with glass.
Is it Ama Epo?
Yes, my lord, she's the one. I don't know if this thing is on mute.
It's
She's
unmute
online.
now. All counsel have been unmute.
Yes, my lord.
Maybe she's having problem with her connection. Appearance for the defendants. Appearance for the defendants.
My lord, it seems she's trying to connect. She's trying to unmute her Zoom. She's here.
Okay. It's only one person I'm seeing that is mute. And that one is our own NIC and is our control. But all the other online, they have not been muted. Okay, there is one. Another one, yes. Counsel for the defendant, unmute yourself. Counsel for the defendants, unmute yourself. Unmute yourself and announce appearance. Yes.
With due respect, my lord.
Yes.
Ama Epo,
Ama Epo.
Deputy Director.
Yes.
Minister of Justice, Calabar.
Yes.
My appearance is for all the defendants.
Are you appearing for who?
I'm appearing for all the defendants, my lord.
Okay. This matter is for judgment. The judgment of the court is ready. And it goes like this. This suit was commenced by originating summons dated 6th day of March 2020 and filed on the 12th day of March 2020, wherein the claimant submitted 2 questions for determination. They are: 1, whether by the provision of Section 1A and B of the Cross River State Gubernatorial Pension Law 2005 as amended in 2015, the claimant, who was Speaker of the Cross River State House of Assembly from 2011 to 2015, and acting governor of Cross River State from the 27th day of January 2012 to February 2012, is not entitled to payment of pension benefit attached to the office of the governor of Cross River State. 2, and if the answer to question 1 above is in the affirmative, whether there is any legal basis or justification for the second defendant to stop the payment of the benefits provided under the gubernatorial pension law of Cross River State to the claimant. In anticipation of favorable consideration or resolution of the questions posed for determination by the claimant seeks for the following reliefs. They are: 1, a declaration that the claimant, having been an acting governor of Cross River State, is within the provisions of Section 1A and B of the gubernatorial pension governor of. 2, a declaration that the action of the defendants, particularly second and fourth defendant, in stopping the payment of pension benefits to the claimant is an infringement of the claimant's right as provided for in the gubernatorial pension law of Cross River State, and thus illegal, unlawful, and ultraviolate their powers. 3, an order of mandatory injunction directing the defendant, particularly the first defendant, to forthwith compute and pay to the claimant all his entitlement, pension benefits, and such other remuneration due to him as provided for in the Cross River State gubernatorial pension as amended in 2015. 4, an order of mandatory injunction directing the defendants, particularly the first defendant, to compute and pay to the claimant the sum of 27 million naira, 590,000 naira, 156 naira, 45 kobo, being the differential in the pension benefit payment made to the claimant from June 2015 to February 2019 at the rate of 611,536 naira 80 kobo per month. 5, an order of mandatory injunction directing the defendants, particularly the first defendant, to forthwith compute and pay to the claimant the sum of 23 million 631,200 and 2020, and thereafter to the date of judgment. The summary of the claims is captured in the body of the judgment. Relief number 6, interest on the judgment of 10% per annum from the date of judgment. The sum is fulfilled as if the debt is fulfilled. 7, relief number 7, an order of perpetual injunction restraining the defendant, stopping the payment of the gubernatorial pension or any other remuneration, entitled or benefit provided for the Cross River State Gubernatorial Law 2000 Pension Law 2005 as amended in 2015 to the claimant, or in any other form. or manner howsoever interfering with the claimant's right to the enjoyment of the privileges and benefits provided thereunder. The originating summons is supported by a 31 paragraphs affidavit and 4 exhibits marked as exhibit MEU1 to MEU4. A written address was also filed along with the originating summons. The facts that gave rise to the institution of this case have been captured in the body of the judgment. So I will skip those ones. Counsel will read them when they obtain copies of the judgment. In his submission before the court, the learned Silk in the written address formulated a single issue for determination, to it, whether considering the provisions of Section 1A and B of the Cross River State Gubernatorial Pension Law 2005 as amended in 2015, and the totality of the facts of this case, the claimant who was acting governor of Cross River State from 27th day of January to February 2012 is entitled to the relief sought. Counsel canvass argument, I have captured the argument of the learned Silk in the body of the judgment. So counsel will have the opportunity of reading when they get copies of the judgment, the hard copies. Although the soft copy will be ready, they will get it on our website either today or tomorrow. Then in reaction to the originating summons, the defendants also filed a counter affidavit and also a written address wherein they also formulated issues for determination. The arguments of counsel, Mr. Iyamba, who appeared for the defendants when the oral argument was canvassed, adopted the counter affidavit, which was sworn by Mr. Eded Ekfo Eni, a chief litigation officer in the chambers of the litigation department of Cross River State Ministry of Justice. The counsel canvass argument in the written address. The argument have been captured in the body of the judgment. So counsel will see the judgment captured therein. In concluding, counsel asked the court to resolve the issue in favor of the defendant and dismiss the case of the defendant. Light of law, wherein he adopted the single issue formulated by the defendant and responded to the argument canvassed by the defendant, that has also been captured in the body of the judgment. Then the defendants also filed a preliminary objection challenging the competency of the originating summons. Argument have been canvassed. The grounds for the objection are that the suit is incompetent, having been commenced by originating summons, as the facts are replete with contentious issues. Argument have been canvassed, and the counsel for the claimant also responded to the notice of preliminary objection. All the arguments for and against have been captured in the body of the judgment. I will go straight away to the decision of the court in order to save time. I have carefully considered the originating summons commencing this suit, as well as the counter affidavit filed by the defendant in opposition. I have equally considered the notice of preliminary objection filed by the defendants and the response by the claimants. On the second day of March 2021, once this matter came up for hearing, I took argument in respect of both originating summons of the claimant and the notice of preliminary objection filed by the defendant challenging the competency of this suit being commenced via originating summons. I shall start with the preliminary objection. For the defendant, this suit was not properly commenced via originating summons. According to the defendant, the facts disclosed in the affidavit evidence are contentious. In the circumstances, this suit ought to have been commenced by use of complaint, general form of complaint, and not originating summons. The claimant respondent on his part submitted before the court that this suit was properly commenced via originating summons. According to the claimant, there are no disputed facts that will warrant use of complaint. It is also the position of the claimant that the originating summons is simply seeking for interpretation of the provisions of Cross River State Gubernatorial Pension Law 2005 as amended by the 2015 law. The provisions of Order 3, Rule 1 of the National Industrial Code Civil Procedure Rules 2017 is very clear and unambiguous. By these rules, this court by this rule, origination summons can be resorted to before this court where the party is seeking for interpretation of constitutional provisions or any statute law or document. It can also be employed by a litigant for purposes of ventilating his grievances before the court based on facts that are not notoriously contentious or disputed. See Order 3, Rule 16. Rules 16 and 17 of the National. It's apparent from the provisions of Order 3 of the rules of this court that originating summons is best suited for cases where there are no substantial dispute of fact. Therefore, originating summons should only be applicable in circumstances where there is dispute on the question of facts or even likelihood of such dispute, or for situations requiring interpretation, where it is obvious from the state of the affidavit evidence that there would be an air of friction in the proceedings, then an originating summons is not appropriate. Originating summons should be used only where the proceeding involves question of law rather than disputed facts. Even where the facts are not in dispute, the origination summons should not be used if the proceedings are hostile. See the case of SCS Company versus Council of Obapemi Awolowo University, Ile-Ife, reported in 2011-14 Nigerian Criminal Report, Part 1269, page 193. See also Sani versus Kogi State House of Assembly, reported in 2019 for Nigerian Criminal Report, Part 1661, page 172. See also Ole versus Tunji, 2013-10 Nigerian Criminal Report, Part 1362, page 275. As pointed out earlier, generally originating summons is used for non-contentious action. That is those actions where facts are not likely to be in dispute. Where facts are in dispute or riotously so, an originating summons procedure will not avail the claimant, and he must come by way of complaint. See proviso to Order 3, Rule 17 of the rules of this court. In other words, an originating summons will not lie in favor of a claimant where the proceedings are hostile in the sense of violent dispute. See Inakoju versus Adeleke, Part 1225, for 423. See Osumbade versus Oyewumi, 2007, on Federation Criminal Report, Part 368, page 1004. The court, in determining whether or not a suit was rightly commenced by originating summons, the court is not called upon to resolve dispute of fact, but to apply the law as to when a suit can be commenced by originating summons. To the facts in the affidavit in support of the originating process, and in some instances, the facts in the counter affidavit opposing the processes to see if they are potentially hostile or indeed hostile. The Court of Appeal has, in the case of Ouma versus Obasi, reported in 2011, 1 Nigerian Criminal Report, Part 1228, page 431, held that once a court is called upon to determine facts which parties must prove by oral evidence, even though documentary evidence would also be put in issue, such proceedings are hostile. Proceedings are hostile, and the use of originating summons is totally unsuitable. In the instant case, the questions submitted for determination and the facts deposed to by the parties in their various affidavits before the court point to the fact that the proceedings will not likely be contentious. The issues to be resolved revolve around interpretation of the provisions of the gubernatorial pension law. In the circumstances, this suit was rightly commenced. To my mind, it is appropriate to commence this action by originating summons. The law has been settled beyond any reproach that where the suit is for interpretation of statute or instrument, as in this case, or where the facts as disclosed in the affidavits of, in this case, the case is suitable for determination by originating summons. I should stress here that the defendant in an action commenced by originating summons by filing a counter affidavit does not tantamount to the matter being contentious or hostile. The dispute on facts, which will necessitate finding that a suit was not formally commenced by use of originating summons, must be substantial material and affecting the live issues in the matter. Where the disputes are peripheral and not material to the live issues, an action can be commenced by originating summons. In this case, there is no substantial dispute of facts that will warrant the calling for evidence. The claimant is only claiming to be entitled to be paid under an amended law. The determination of whether he is entitled or not to the benefit will depend on interpretation of the amended law. And this is within the province of the court. It is the court that has the bounden duty of interpreting the law and not the parties in a matter. In the circumstances, I have no doubt in my mind that this suit was properly commenced by originating summons. The area to which the defendant pointed out as areas of dispute are as such not in dispute. There are no abatement in the counter affidavit disputing the claim of the claimant as being an elected House of Assembly member. There is also no dispute as to the claimant's claim of having served as Speaker of Cross River State House of Assembly. There is also no dispute that the claimant had served as acting governor of Cross River State at a time. In view of all the above findings, the objection of the defendant to the competence of this suit being commenced by or at least any conflict in the facts of the case, or that the suit was not for interpretation of provisions of a statute. The objection is hereby dismissed. I shall now consider the substantive claim of the claimant as per his originating summons. In the originating summons, the claimant submitted twin questions for resolution. They are whether by the provisions of Section 1A and B, the Cross River State gubernatorial pension law, the claimant who was Speaker of the Cross River State House of Assembly from 2011 to 2015 and acting governor of Cross River State from 27th of January 2012 to February 2012 is not entitled to the payment of pension benefits attached to the office of governor of Cross River State. 2, and if the answer to question number 1 above is in the affirmative, whether there is any legal basis or justification for the second defendant to stop payment of benefit provided under the gubernatorial pension law of Cross River State to the claimant. In anticipation of the court resolving the 2 questions in his favor, the claimant sought for 7 reliefs from the court. The reliefs have been reproduced in the earlier part of this judgment, and they need not be reproduced here again. Out of the 7 reliefs being sought by the claimants, 2 are for declarations, while the remaining 5 reliefs are ancillary or dependent on the grant of the two declarations. Authorities that a party praying for grant of declaratory relief must succeed on the strength of his case and not on the weakness of the defense or admission. The burden of proof in declaratory relief is very heavy one, that a party must convince the court that he is entitled to the reliefs in the fullest sense. The Supreme Court has captured the difficulty of proof in declaratory relief in the case of Dumes Nigeria Limited versus Nwakoba, reported in 2008 LPELR 965 SC, where it stated as follows: the law on the requirements of plaintiff to plead and prove his claim for declaratory relief on the evidence called by him without relying on evidence called by the defendant is indeed well settled. The burden of proof on the plaintiff is established in establishing declaratory relief to the satisfaction of the court is quite heavy, in the sense that such declaratory reliefs are not granted even on admission by the defendant, where the plaintiff fails to establish his entitlement to the declaration by his own evidence. In other words, declaration of right is sought by the plaintiff respondent in their first relief against the defendant appellant in the present case, cannot be made on admission or in default of pleading by the defendant, not to talk of reliance on the evidence of the defendant witness, unquote. By the decision in 7-Up Bottling Company PLC versus Augustus, reported in 2012 LPELR 20873CA, the claims for gratuity, pension, housing fund, salary are all special damages and must be strictly proved. See also NNPC versus Kilifo Nigeria Limited, reported in 2011 LPLR fails where a claim falls in this test, fails this test, the claim must fail. Additionally, in a decision of this court, in the case of Mr. Surajo Rufai versus Bureau of Public Enterprises and others, are reported suit number NICNLA/18/2013, the judgment of which was delivered on the 1st of June 2018. This court stressed that in labor relation, the burden is on the claimant who claims monetary sums to prove not only the entitlement to the sum, but how he or she came by the quantum of the sum. And proof of entitlement is obtained by reference to an instrument or document that grants it. See also Mr. Mohammed Dungus and others versus ENL Consortium Limited, reported in 2015, 60NLLR, part 208, page 39. Not the oral testimony of the claimant, except if corroborated by other credible evidence. In fact, in the case of Mr. Joseph Akinola versus Lafarge Wafco Nigeria Limited, reported in 2015 LPLR 24630CA, specifically caution against reliance on oral evidence as proof of such entitlement. The claimant in this case has specified the quantum of his claim and has particularized them. What remains to be seen is whether there is evidence of proof of entitlement by reference to statutory or any other instrument that entitle the claimant to the claim before the court. The claimant relies on provisions of section 1A and B as the instrument that grants him entitlement to all the reliefs he claims. The facts which the claimant relies in proof of his case are to the effect that on the 11th day of June 2011, the claimant was elected on the floor of the Cross River State House of Assembly as the Honorable Speaker of the House, a position the claimant held till June 2015, when the House stood dissolved, when the tenure of the House came to an end. However, following the annulment of the election of the then governor of Cross River State, Senator Leal Imoke, by the election tribunal, the claimant was sworn in as acting governor of Cross River State, the position he held from 27th day of January 2012 till February 2012. A rerun election was conducted by the Independent Electoral Commission, INEC, and Senator Liel Emoke, then the governor whose election was annulled, emerged winner of the rerun election, and he was sworn in as the substantive governor of Cross River State. Consequently, the claimant reverted back to his position as Speaker of the State House of Assembly till the end of the tenure of the House in June 2015. The claimant, in reliance on the above stated facts and on Section 1A and B of the amended Cross River State Gubernatorial Pension Law 2005, amended by 2015 amendment, filed this suit to press for payment of pension as a governor of Cross River State. The defendants are vehemently opposing the claim of the claimant as per their counter affidavit and the written address filed before the court. The main issue to be resolved is whether the provisions of Section 1A and B of the Cross River State Pension Law 2005 as amended in 2000 pension as governor of Cross River State for having served as acting governor from 27th day of January 2012 to February 2012. The decision of the court will be based on proper interpretation of the relevant provisions of the pension law and the constitutional provision donating the power to the State House of Assembly to enact such law. The guiding rule rules on interpretation of statutes or instrument is well settled by a plethora of authorities. One of the vital canons of interpretation of statute or written instrument is to give plain words of the statute their ordinary, natural, and literal grammatical meaning. In order to establish the intention of the lawmaker or the premise of the statute or instrument, it is only where ordinary or literal meaning of the clear and unambiguous words fails to bring out the intention of the lawmaker or lead to absurdity that result is hard to constructive interpretation. See the case of Dixon versus Silva, reported in 2017, 8 Nigerian Law Report, part 1567, page 167 at 233, paragraph B, 5KK Okun JSC. See also registered trustees of the Airlines Operators of Nigeria versus Nigerian Airspace Management Agency, reported in 2014, 8 Nigerian Law Report, part 1408, page 1 at page 41, paragraphs B to C. See also the case of Ameti versus INEC, reported in 2008, 5 Nigerian Law Report, part 1080, page 227. This principle also applies to interpret for the well laid down position for the interpretation of Constitution is that once the words used are clear and unambiguous and are free from ambiguity, they should be given their natural meaning without any embellishment. Provisions of the Constitution must always be interpreted to achieve the obvious end for which the Constitution was promulgated. See Assam versus Ararume, reported in 2016, 1 Nigerian Law Report, part 1493, page 368 at 387, paragraph A to C. See also as per Road Bibles, where an interpretation will result in breaching the object of the statute, the court will not lend its weight to such an interpretation. See Dixon versus Silva Sufra. However, where there is a gap, duplicity, or ambiguity, or where the words of an enactment are capable of two meanings, a contextual rather than a literal approach should be preferred, as it is the duty of the court to give a meaning that will resonate with sense, order, and a workable system. In so doing, the provision of a statute must not be read in isolation, but the whole, to ascertain true meaning of the statute. See Buhari versus Obasanjo, 2005, All Federation Law Report, part 273, page 1 at 189. First Action Law of blessed memory. See also the case of Braithwaite versus GDM, reported in 1998, 7 Nigerian Criminal Report, part 557, page 307. For Ayola JCA as season was. See also Akpambo versus Okadi. It is equally vital to read all the integrated and interrelated statutory and constitutional provisions under Constitution together, not in isolation or by installment. See the case of AG Benue State versus Umar, 2008, 1 Nigerian Criminal Report, part 1068, page 611. See also Dimegu versus Ogunewe. See also trustees of ETC versus My Medical Health Workers Union, and the case of Inakoju versus Adeleke Sufra. It is in line with the above well laid down principles of interpretation of statute and the Constitution that I shall consider the provisions of Cross-River State Gubernatorial Pension Law and the relevant provisions of the Constitution of the Federal Republic of Nigeria, 1999, as amended. It is by so doing that the court will be able to reach a just decision of the question forced for resolution in the originating summons. It is apt at this point to reproduce the provisions of Section 1A and B of the Cross River State Gubernatorial Pension Amendment Law 2014. It provides: 1. The Cross River State Gubernatorial Pension Law 2005, hereinafter referred to as Principal Law, is hereby amended as follows. A. Delete the long title and substitute therefore the following long title as follows: a law to provide a pension to any person who has held office of a governor, deputy governor, speaker, or deputy speaker in Cross River State for the and for the matters connected therewith. B. Add immediately after Section 3 of the Principal Law a new section 4 as follows: pension for Speaker and Deputy Speaker of the Cross River State House of Assembly shall be entitled to the pension granted by the Principal Law, where he has served as Speaker for a period of not less than 2/3 of his tenure of office, except the person ceased to hold office at any time on ground of specified in Section 92 of the Constitution, or he is removed from office pursuant to Section 107 of the Constitution. The claimant also relied on Section 1C of the same law, the interpretation of the word governor or deputy governor. Section 1C provides: delete Section 4 of the Principal Law and substitute therein the following new Section 5 as follows. Interpretation 5. In this law, unless the context otherwise requires, governor or deputy governor means governor, deputy governor, or acting governor of Cross River State. According to the claimant, the definition is the definition in Section 5 of the law is what brings and therefore entitled to be paid the pension benefit equivalent to that of a former governor as provided for in the law. It is pertinent to point out here that the Cross River State House of Assembly that enacted the Cross River State Gubernatorial Pension Law 2005 as amended in 2015 derives its power in the enactment of the provisions of the Gubernatorial Pension Law from the provisions of Section 125, subsection 5 of the Constitution of the Federal Republic of Nigeria as amended. Section 124, subsection 5 of the Constitution provides. It reads: provisions may be made by a law of a House of Assembly for the grant of a pension or gratuity or a respect of a person who has held office as governor or deputy governor and was not removed from office as a result of impeachment or breach of any provisions of the Constitution, and any pension or gratuity granted by virtue of any provision made in pursuance of this subsection shall be a charge upon the Consolidated Revenue Fund of the state. The defendants have insisted that the provisions of Cross River State Gubernatorial Pension Law 2015 is null and void, for it includes acting governor as one of the persons to benefit from the payment of pension as a governor. According to the defendant, the acting governor only filled a void, and he reverted back to his position as speaker and ended his tenure as speaker and not as a governor or acting governor to make him to be entitled to payment of pension as a governor. The claimant in response insisted that the provisions of section 1A and B and 5 of the pension law is very clear and unambiguous and should be accorded ordinary literal interpretation. The parties herein have joined issues with respect to the validity of Cross River State Gubernatorial Pension Law as amended in 2015. Generally, a law elected either by the National Assembly or a State House of Assembly, like in the case at hand, must be consistent with the grand norm, i.e. the Constitution, as amended. Otherwise, it will run contrary to the consistency doctrine of law. In event of any conflict, the law will give way to the Constitution. It is to be noted that the Cross River State House Assembly was donated power of making or enacting pension law by Section 124(5) supra. This means that in exercising such power donated to it by the House, donated to the House of Assembly, the House of Assembly must act within the purview of the provisions of the Constitution that donated the power of making the law. This means any deviation from the tenor and intendment of the provisions of Section 124, subsection 5 supra, will be an exercise in futility. See the case of Bamboy versus University of Ilorin. See also Obiebu versus CBN. In the case of National Union of Electricity Employees and another versus Bureau of Public Enterprises, reported in 2010 LPELR 966SC, it was held thus: it is right law that under the consistency test that the validity of any law is determined by its consistency with the provision of the supreme law, that is the Constitution. So that where any law is inconsistent with any provision of the Constitution, such other law shall, to the extent of inconsistency, be void. In support of these provisions, see Military Governor of Ondo State versus Adeumi, reported in 1988, Sri Nigerian Ukilolo Report, Part 82, page 280. Also, see the Attorney General of Ondo State versus the Attorney General of the Federation, reported in 2002, 9 Nigerian Ukilolo Report, Part 772, page 222, far away Y4 JSC. This means that the power of the legislature to make law is circumscribed by the Constitution, meaning that where there is conflict in between the Constitution and the law made by House of Assembly, the law enacted by the House of Assembly in excess of its power must give way to the provisions of the Constitution to the extent of its inconsistency. I have scrutinized the provisions of Section 124(5) of the Constitution as amended, and I am satisfied that the said provisions of the Constitution did confer on the Cross River State House of Assembly the power to enact a law to make provisions for grant of pensions to governor and deputy governor of the state. However, there is no equivalent power in Section 1245 of the Constitution for making provision for pension for the acting governor of the state or speaker or of House of Assembly or his deputy. This means that the gubernatorial pension law amendment of 2015, which came into force on the 19th day of May 2015, made with the sole aim of making provisions for payment of pensions to acting governor of the state the speaker and his deputy was made without bias. The said amendment, having been made without the requisite power, is null and void and of no effect whatsoever. The provisions of Section 318 of the Constitution of the Federal Republic of Nigeria 1999, as amended, clearly and in unambiguous terms, define governor, a deputy governor, to mean governor of a state or a deputy governor of a state, and there was no mention of acting governor or speaker of the House of Assembly or his deputy. The Constitution of the Federal Republic of Nigeria 1999 as amended has also left no one in doubt as to who is a governor or deputy governor of a state. This can be found in the provisions of Section 173, 176, 178, 179, and 180 of the Constitution of the Federal Republic of Nigeria 1999 as amended. The combined effect of these constitutional provisions will reveal that an acting governor is not a governor for the purpose of provisions of Section 124 subsection 5 and Section 138 of the Constitution of the Federal Republic of Nigeria as amended. Likewise, the speaker or his deputy are equally not governor or deputy governor in the real sense. So they are never contemplated by the Constitution to be meant to benefit from pension provided for under Section 124 subsection 5 of the Constitution of the Federal Republic of Nigeria 99 as amended. The above position taken by me is further supported by the fact that the tenure of a governor is for 4 years, commencing from the date of taking oath of office. However, where there is a rerun, like in the case at hand, that necessitated the claimant to serve as acting governor for 32 days. In determining the 4-year tenure or terms where a rerun election has taken place, like in the case at hand, since the candidate that won the rerun has taken oath of office, but his election has been annulled, the terms of 4 years will start to count on the date he first took oath of office, and not from the date he took oath of office after rerun. The time spent in office between the date of his election, between the date the election was annulled, shall be taken into account in computing the time, the tenure, the terms for his tenure. See also the case of, see also Section 180 subsection 2A of the 1999 Constitution as amended. This provision has clearly established that the period of action is computed as the period for the tenure of the governor that won the rerun election and was sworn after the rerun. It also means that the period which the claimant served is not accounted to the credit of the claimant, but to the credit of the person that won the rerun election. With this exposition, I am tended to quite agree with the defendant that if pension is granted to the claimant as a governor, it means 2 governors existed at the same time, which is not possible. In view of the foregoing, by use of the holistic mode of interpretation, by considering the integrated and interrelated provisions of the pension law and those of the Constitution, the House of Assembly does not have the bias to make the provisions for pension for acting governor or speaker or his deputy. This is because the provisions of the Constitution that donated the power to enact such pension law clearly excluded acting governor, speaker, or his deputy. It is right that the express mention of one thing in a statutory provision automatically exclude any other, otherwise would have applied by implication. With regard to the same issue, see the case of Ehua versus Osayek, reported in 2006, 10 Nigerian Colonial Report, page 1012, page 444, where the Apex Court held it is now firmly established that in construction of statutory provisions, where a statute mentions specific things or persons, the intention is that those not mentioned are excluded to be included. The Latin maxim is expressio unius est exclusio alterior, i.e., the expression of one thing is the exclusion of another. The premise of the Constitution having expressly excluded acting governor in section 124(5) of the Constitution, the House of Assembly does not have the power to include acting governor in the pension of the local government and his deputy. If, on the other hand, it was found out that the 2015 amendment of the pension law is valid, if on appeal it is found that the 2015 amendment is valid, which I do not think so, I still maintain my position that the claimant cannot benefit from the provisions of section 20, cannot benefit from the provisions of 2015 amendment for the simple reason that the law was amended after the claimant has served as acting governor, and he reverted back to his position as a Speaker of the State House Assembly, and his tenure ended as Speaker in June 2015, and not as acting governor or governor. From the facts of this case, which are not in dispute, the claimant served as acting governor of Cross River State from 27th day of January 2012 to February 2012, when the winner of the rerun election assumed duty as a substantive governor of Cross River State. This means that the claimant's course of action respecting serving as acting governor arose in February 2012. It is settled by long chain of decided cases that the law applicable to a case or course of action is the law enforced when the course of action arose, and not the law applicable when the action on the course of action was instituted. In the case at hand, the pension law applicable in Cross River State as at February 2012, when the claimant served as governor of the state, is the gubernatorial pension law 2005, and not the amended law as at 2015. It has been settled beyond any reproach that the relevant law applicable in respect of a cause or matter is the law imposed as at the time the cause of action arose, and in the case of the law relating to jurisdiction when the action was instituted. See Y4 versus Attorney General of Benton State, 1982 to 83, for NCLR 1. See also the case of Attorney General Lagos State versus Dosumo. In Obweb versus CBN, the Supreme Court followed by both JSC stated that the law enforced or existed at the time a course of action arose is the law applicable for determination of the case. That is to say, the law enforced as at the time a course of action arose governed determination of the suit, while the law imposed as at time of trial based on the course of action determine the law based in jurisdiction in the court. Though the legislature in regard to civil matters has unfettered power to make or enact legislation retrospectively, nevertheless, it is a well-settled principle of law that an act of parliament cannot be construed as having retroactive effect unless there are express words in the enactment showing such an intention. This is based on the presumption that the legislature does not
Have.
presumption that the legislator does not intend what is unjust statute. What is unjust? Statutes are construed as operating only in cases or on facts which came into existence after the statutes were passed, unless a retroactive effect is clearly intended. See Ojo Kolobo Alamu, reported in 2004, All Federation Weekly Report, part 237, page 569. See also Afolabi versus Governor of Oyo State, reported in 1985, 2 Nigerian Weekly Report, part 9, page 734 at 752 to 753. The general principle in regard to the prospective operation of statute is based on the presumption that legislature does not intend what is unjust and therefore cannot lean against giving certain statute active operation. They are construed as operating only in cases or where facts which came into existence after the statute were passed unless a retroactive effect is clearly intended. See Afolabi versus Governor of Lagos State, Governor of Oyo State, sorry. The general principle of law against retroactivity is in accord with the common sense. For retroactivity is entirely artificial. It is a cardinal principle of law that a statute operates prospectively and cannot apply retroactively unless it is made to do so by clear and express
Provision of the law.
It is made to do so by clear and express terms, or it only affects purely procedural matter and does not affect the right of the party. The provisions of the statute are generally meant to apply to future events unless the provisions expressly and unambiguously stated that they are retroactive. See Apolabi versus Governor of Oyo State Supra. See also Ibrahim versus Barde, reported in 1996, 9 Nigerian Report, part 474, page 513. It is a fundamental rule of English law that statute shall be construed so as to have a retroactive operation, so as not to have a protective operation unless it is its language is such that as plainly to require such construction. And the same rule involve another and subordinate rule to the effect that a statute is not to be construed so as to have greater retroactive effect than its language rendered necessary. In applying the above principle of law to the facts of this case, it will be right to state that the claimant who has his course of action materialized in February 2012 at the end of his acting can only institute an action to claim pension for acting governor for a law in operation as at February 2012. However, as pointed out earlier, as at February 2012, the claimant does not have right to claim pension, as such right does not exist. Therefore, it will be wrong for the claimant to now approach the court for redress on an amendment not enforced when his course of action arose in February 2012. The change in the law is clearly no comfort to a claimant whose injury arose in February 2012 when the pension law is imposed as at then was
2005.
when the law is enforced as at 2005 pension law and not the amendment made in 2015, which was not in existence as at February 2012 when the claimant's course of action accrued. See the case of AG Lagos versus Dosmo. If there was no course of action, a subsequent alteration of the law cannot supply the incurable legal deficiency. The case of the claimant to make claim under the provisions of 2015 amendment was made worse when Section 2 of the amendment clearly stated that commencement date of the 2015 amendment shall be 19th day of February 2015, and as at 19th day of May 2015, and as at 19th day of May 2015, the claimant was not acting governor of Cross River State. This has established that even if acting governors are to benefit from the amendment, the claimant has been excluded by the date of commencement of the amended pension law. If the lawmakers had intended the law to be retroactive, they would have been stated so in unambiguous terms by fixing commencement date of the amendment to the 2015 to be 19th day of May 2015. The law was never intended to have a retroactive effect. This means the presumption against retroactive laws stand unshaken for lack of evidence, a rebuttal. The claimant would have been able to claim as speaker because his tenure ended in June 2015 after the coming into force of the 2015 amendment. Also, this court has found that the 2015 law was even enacted without the requisite power. He cannot as well claim under a null and void law made without a requisite power to do so. In view of the foregoing, the claimant in this case does not have a valid course of action to enforce, as there is no law to aid him in his quest to enjoy the benefit of granted to governor upon expiration of his tenure. This is because it is a fundamental principle of interpretation of statute that unless there is express provision therein or a clear intention that the provision shall operate retroactively, there is a presumption against retroactivity. See University of Calabar versus Adam Malekun reported in 1967 All Nigerian Law Report, page 213. See also Ige versus Obi Wale, 1967 All Nigerian Law Report, page 276. For avoidance of doubt, the claimant in this case has willfully failed to prove his entitlement to any of the relief sought. The case is lacking in merit and same is hereby dismissed. The claimant shouldn't have instituted this matter as he has no course of action to enforce. In the circumstances, I dismiss the claimant case. I make no order as to cost. Judgment entered accordingly.
Thank you, my Lord. I'm most grateful.
My Lord, we're very grateful for this well-considered ruling judgment.
Yes.
I'm most grateful, my Lord.
You are
Thank you.
welcome.
Yes.
You can access the judgment online at you can access the judgment on our website by tomorrow.
Okay, my Lord. Thank you.
Before you get the hard copy.
Very well, my Lord.
Registrar, call the next case. Call the next case. Registrar, call the next case. Registrar, unmute yourself and call the next case. Registrar, unmute yourself and call the next case. Our counsel in this matter, our counsel in the case of NIC and CA, stroke 2028 stroke 2020. Our counsel present.
Yes, my Lord.
We have lost the registrar.
My Lord, the counsel for the claimant respondent is present.
Okay. Announce your appearance. Appearance for the claimant. NIC.
Respecting my Lord.
Yes.
Respectfully, my Lord.
Yes.
R.A. Manga. My
R.A.
Lord, I am
Manga.
the claimant and I appear in person. Raymond Manga, Esquire. I appear in person as the claimant respondent.
Yes. Yes, any appearance for the defendants? Any appearance for the defendants? Any appearance for the in the absence of the, I'll go ahead. This matter is for ruling. The ruling of the court is ready.
As the court pleases.
This deals with two applications. The first being a notice of preliminary objection filed by the defendants, while the second application is a motion on notice filed by the claimant for amendment of his originating process commencing the suit. The notice of preliminary objection was brought pursuant to Order 17 Rule 1 of the National Industrial Code Civil Procedure Rules 2017, Section 272(1) of the Constitution of the Federal Republic of Nigeria as amended and under the inherent jurisdiction of the court. The notice of preliminary objection is praying for the following reliefs. 1, an order dismissing or striking out the claimant's suit as contained in the general form of complaint, statement of facts, together with all accompanying processes for want of jurisdiction. In the alternative, an order directing that the dispute in this matter be referred to an arbitrator as contained in provisions of Clause 9 of the service agreement executed between the claimant and the first defendant. 3, an order of this court to stay further proceeding in this suit pending the hearing and arbitral award. 4, and for such further or other orders as this honorable court may deem fit to make in the circumstances. The grounds for the objections are as follows. A, by this suit, the claimant seeks to impose service agreement of 1st November 2017 for recovery of fees for services rendered to the first defendant as a solicitor in the third quarter, that is July to September 2020, and for damages for alleged breach of service agreement. This honorable court, with respect, lacks the jurisdiction to entertain or adjudicate upon a suit seeking recovery of solicitor's fees and or alleged breach of solicitor's service agreement. The claimant herein is not and has never been an employee of the defendant. The jurisdiction of this court in civil causes and matters is limited to dispute arising from payment or non-payment of salaries, wages, pensions, gratuity, allowances, benefits, and any other entitlement of any employee, worker, political or public office holders, judicial officer, or any civil public servant in any part of the Federation, and matters incidental therein. The extant suit is an invitation to this court to enlarge the scope of jurisdiction of the court as provided for under Section 254C1K of the Constitution of the Federal Republic of Nigeria 1999 as amended. This honorable court, with due respect, does not have the competence to enlarge its own scope of jurisdiction. 8, the dispute in this suit is in respect of breach of contract and and same is within the exclusive jurisdiction of the State High Court by virtue of Section 272 of the Constitution. With regard to the alternative prayer 2 and 3, the grounds for the objection are as follows. The claimant and the first defendant in this suit by the service agreement at clause 9 provided for as follows. Any dispute should be firstly resolved through mutual reconciliation. In the event of a dispute cannot be resolved by the parties, thereto such dispute may be referred to an arbitrator registered with Nigerian Arbitration Commission. The notice of preliminary objection is supported by a 19 paragraphs affidavit sworn to by counsel appearing for the defendant. The facts deposed in the affidavit in support are a rehash of the grounds for raising the objection. A written address was also filed along with the notice of preliminary objection. In it, twin issues were distilled for resolution. They are: one, whether the claimant's abatement in this suit should not be dismissed and or struck out for want of jurisdiction. Two, whether jurisdiction of this honorable court is not suspended by the arbitration clause contained in the underlying service agreement executed between the claimant and the first defendant. It is submitted. The argument of the counsel has canvassed argument on the two issues. The argument has been captured in the body of the judgment, so I need not to go over them. Counsel concluded that, in concluding, counsel contended that the parties are bound by the agreement that the court should be ordered for arbitration. A reaction to the notice of preliminary objection, the claimant filed an 8 paragraphs counter affidavit with a written address in opposition. In the written address, counsel for the formulated twin issues for resolution. The twin issues are whether, considering the facts and circumstances of this case, the employment relationship between first applicant and the respondent is that of contract of service or that of contract for service. Two, whether the respondent's action is incompetent by virtue of arbitration clause contained in the service agreement. Argument on the two issues have been captured in the body of the judgment, so I need not to go over them. I shall proceed to go to the decision of the court. I have carefully and painstakingly perused the two applications filed by the parties in this suit. I have equally listened attentively to submissions of counsel for and against the application. There is no doubt that the application of the claimant, which is for amendment of the originating process commencing this suit, is an attempt geared toward curing some identified defects by the notice of preliminary objection filed by the defendant to discharge the competency, to challenge the competency of this suit. The law is well settled that where there are two applications before the court, one destructive and the other salvaging, the court is enjoined to first and foremost consider the application that is meant to bring back to life the suit. By orders 26 of the rules of this court, by orders 26 of the rules of this court is empowered to entertain an application for amendment of processes from the court before the court, provided such amendment will not prejudice the other party or establish a different course of action. I have carefully examined the originating processes filed in this suit, as well as the amendment being sought by the claimant. It is clear to me that the amendment being sought by the claimant is to save the suit from extinction. The defendant did not file any counter affidavit to oppose the application for amendment. In the circumstances, I find the claimant's application to be meritorious, and the same is hereby granted. I now turn to the first application, which is the preliminary objection to the competence of the suit on the ground that there is also the challenge that even where the court found that it has jurisdiction to entertain this suit, it nevertheless cannot entertain it as there is mandatory clause for arbitration, which the parties have voluntarily signed. For the claimant, this court has jurisdiction to entertain this suit as it is based on employment, and the contract between the parties is that of contract of service and not contract for service as canvassed by the defendant. In the case of Uti versus Onoibue, in the case of Uti versus Onoibue, reported in 1994, Nigerian Kilolo Report, Part 166, page 54. Velo JSC, as his name was, of blessed memory, has this to say on jurisdiction. Jurisdiction is blood that gives life to the survival of an action in a court of law. And without jurisdiction, the action will be like an animal that has been drained of its blood. It will cease to have life, and any attempt to resuscitate it without infusing blood into it would be an abortive exercise. The importance of jurisdiction to adjudicate cannot be overemphasized, as it has been described variously by courts as life wire, bedrock, blood that gives life, the power or authority which a court possesses to adjudicate over a particular matter or dispute. The question of jurisdiction is the fulcrum or cornerstone of litigation, of all litigation. Consequently, once the jurisdiction of a court is challenged, the court is duty bound to determine whether or not it has jurisdiction first before proceeding to entertain the case. This is so because any order made in such a court without jurisdiction is nullity and remains so for all purposes. See the case in Dayo versus Ogunaya. See also Pundak Engineering versus MacArthur. See also Alao versus COP. See also Rufai versus Olubenga. Therefore, a jurisdiction of court to hear any matter can be raised at any time and at any stage of proceedings, or even on appeal or before the Supreme Court. See the case of ANN Limited versus FRN, reported in 1985. Nigerian Criminal Report, part 6, page 131. It is manifestly clear that for any adjudication to be validly made or have that decided without jurisdiction, nullity, and void and of no effect. Jurisdiction of a court is the foundation on which every adjudication rests. See the case of Manson versus Halliburton Energy. See also Lufthansa Germany Airline versus Odessa. See also Adeleke versus Oshun. See also Nwonye versus Ainde. The national It is to be noted that the National Industrial Court derives its competence to adjudicate from Constitution and Statute. See Section 254C of the Constitution as amended and Section 71 of the National Industrial Act 2006. What the court will consider where issue of jurisdiction is raised, as in this case, is the claim of the claimant and the law establishing the court and conferring jurisdiction. See the case of Farm and others versus ABU and others. See also Afar of Aboki JSC as he then was. By the Constitution of the Federal Republic of Nigeria, third alteration, the Constitution based by Section 254C by the provision of Section 254C1, the National Industrial Court is conferred with exclusive jurisdiction in respect of all civil causes and matters connected or arising from employment and labor-related issues. In the National Industrial Court, in spite of the provisions of Section 254, 251, 257, and 272 of the Constitution. This means Section 254C1 has curtailed the power contained in the provisions of Section 2551, 257, and 272. Furthermore, it is also tried position of the law that it is the law imposed as at the time the cause of action arose that governs Furthermore, it is tried position of the law that it is the law enforced as at the time of cause of action, the cause of action arose that govern the determination of the suit, while the law enforced as at the time trial began on the issue on the cause of action determined or best the court with the requisite jurisdiction, COBO versus CBN. By the amended originating process commencing the suit, paragraphs 2 and 23 of the amended statement of facts by the amended originating summons commencing the suit and paragraph 2 to 23 of the amended statement of facts, the claimant is seeking for declaratory and monetary reliefs. The declaratory reliefs include declaration that his service appointment that his appointment remain valid and subsisting until properly terminated in accordance with the service agreement as stipulated in Article 3. He is also praying for an order setting aside termination of his appointment in the notice dated 7th day of August 2020. There is also relief for declaration that the termination of claimant's appointment is in violation of the service agreement dated 1st day of November 2017. The Constitution There is also a relief for declaration that the termination of claimant's appointment is in violation of the service agreement dated 1st November 2017. and constitute the contract of employment. There are other monetary claims. In the paragraphs of the statement of facts refers to above, the claimant stated that he was engaged as company secretary with the terms and conditions of appointment contained in the service agreement. He also stated that he carries out duties diligently and without any query or compliance with the terms of the service agreement. As shown from the reliefs being sought, therefore, the court, as per the amended general form of complaint and the amended statement of facts, the facts as stated therein borders on wrongful termination of appointment, which is within the purview of the the facts as stated therein borders on wrongful termination of employment of appointment, which is within the purview of National Industrial Code of Nigeria, as contained in the provisions of Section 254C 1K of the 1999 Constitution, as amended. By the claimant's amended statement of facts, the subject matter in this suit is connected with the following due process in ending employment of the claimant. This by the claimant's amended statement of facts, the subject matter in this suit is connected with the lack of due process of law in ending the claimant's appointment and salaries of the company secretary. The law is settled that by the provisions of the Constitution, as amended, only the National Industrial Code has jurisdiction to determine claim based on wrongful termination of or non-payment of salaries of employees. Section 254C1K of the Constitution of the Federal Republic of Nigeria, as amended, states as follows: notwithstanding the provisions of Section 2541, 251, 257, 272, and anything concerned in this Constitution, and in addition to such other jurisdiction as may be conferred on it by the notwithstanding the provision of Section 251, 251, 257, 272, and anything contained in the Constitution, and in addition to such other jurisdiction as may be conferred upon it by an act of National Assembly, the National Industrial Code shall have and exercise jurisdiction to the exclusion of any other court in civil causes and matters relating to, connected with dispute arising from payment or non-payment of payment or non-payment of salaries, wages, pensions, gratuities, allowances, and any other entitlement of any employee, worker, political office or public holder, judicial officer, or any civil or public servant in any part of the Federation, and the matters incidental thereto. In the case of NDIC versus OM Enterprises Limited and another, it was held, among others, that when the term notwithstanding is used in a section of a statute, it is meant to exercise an impeding or impeding others effect of any other provisions of the statute or any where the terms no to something is used in section of a statute, it is meant to exclude an infinite or impeding effect on any other provisions of the statute or other subordinate legislation, so that the said section may fulfill itself. It follows that as used in section 254C1C of the 1999 Constitution as amended, it is clear that the exclusive jurisdiction of this court is beyond dispute as relating to employment and labor-related matters. See cases of SSC Nigeria Limited versus Yusuf and host of other cases quoted therein. The reason being that the inhibition created by section 272, 257, 251 of the Constitution has been dismantled by the liberating force of section 254C1 1K of the Constitution. However, it must be noted that the mere fact that the court has exclusive jurisdiction does not mean that the claimant has succeeded. He still has the burden of proof the finding that this it must be noted that the mere fact that this court has exclusive jurisdiction does not mean that the claimant has succeeded He still has the burden of establishing his case by credible evidence as required by law. The finding that this court has jurisdiction to hear and determine the claim of the claimant, having shown as shown in the amended originating process, is enough to settle the objection. But there is the issue of arbitration clause raised by the defendant. I have carefully perused the arbitration clause contained in Article or Clause 9 of the service agreement. It is clear to me that the arbitration which it is clear to me that the arbitration to which the clause relate, which clause 9 of the service agreement relate, is the arbitration as provided in the Arbitration and Conciliation Act. I must observe here that the provisions of Arbitration and Conciliation Act are meant to govern commercial transaction dispute and not employment or labor dispute. In the circumstances, it is my view that the provisions of Arbitration and Conciliation Act can make dispute, as in this case. With the finding, I expect in the circumstances, it is my view that the provisions of arbitration cannot be used to settle employment dispute, as in this case. With this finding, the aspect of the arbitration clause requiring settlement of dispute by arbitration cannot apply to this case. I must also state that here that the finding on non-application of arbitration clause to the case is without prejudice to the right of the parties to settle their dispute amicably by mediation or conciliation or any other means. It is only the arbitration that is not applicable to this case, as it applies to commercial arbitration. The issue of whether the claimant is an employee or independent contractor is premature to be raised at this stage. That should form part of the defense of the defendant, which has to be proved by evidence, by credible evidence. From all I have been saying above, the claimant's application for amendment of originating process commencing this suit succeed and same is hereby granted as read, while the defendant's notice of preliminary objection to the jurisdiction of this court to entertain this matter fails, and same is hereby dismissed for lacking in merit. I make no order as to cause, ruling entered accordingly.
Court pleases. Thank you, my Lord. We are very grateful. We are very grateful, my Lord. May God continue to bless.
Amen. You know, this matter is, I don't know, counsel, you know, I can't give you a date because I don't know when the strike will end. So I think the best thing to do is to adjourn Senate until when the vacation, when the Jusun finish their strike, then we can fix a date for hearing. While before then, if there is any opportunity to settle amicably, you can still pursue it.
As the court pleases. My Lord, we are okay with that decision. Thank you, my Lord.
Okay. Okay. So thank you very much, counsel, for cooperation, for being patient and being attentive. We have come to the end of today's virtual sitting. Thank you very much. The administrator, you can end the session. Administrator, you can end the session. Thank you, counsel.
Okay. Thank you, my Lord. God bless you, my Lord. Thank you.